You are listening to the Bail Post. Welcome to the next episode of our podcast. We have a very interesting topic for today. We're going to talk about immigration and how that affects bail bonds. And it's kind of like oil and vinegar at times. And today we have a guest who I've known for many, many years. His name is Randy Adler. He is a bail attorney from the state of Texas. I always tell people if I like somebody, I pick on them. And so I pick on Randy a lot. And so, Randy, welcome to our podcast and welcome to me picking on you for an hour.
Thank you, Ken. It's my pleasure to be here. I hope at the end of this session we can still be considered friends, but we'll see how this goes.
Well, we're going to talk about immigration. We're going to talk about, something we've heard at the legislature about ex parte clear. But before we get to that, I think we need to highlight several things that are very important. And that is last week we had a school, but also we had a spring fling where we had a steak cook-off competition. And I placed first.
But you failed to mention that there has been a protest filed. There's documented evidence that you may have used some special ingredient like liquid smoke in your steak, but we're waiting for the lab results to come back on that. So celebrate your victory while you can. It may be
Uh-huh.
short-lived.
Well, and I was wearing my Kansas City Chiefs overalls, my Travis Kelce t-shirt, and my Kansas City Chiefs hat. And I did it just to be stupid because, we had some of us that weren't really getting along at the moment. And I thought, well, if I'm stupid, they'll just talk about how stupid I was. And
Mission
then,
accomplished. Absolutely. Yeah.
and then I won. And so what happened is, after about 30 minutes, somebody came up to me and said, we have an offer of $500 for your overalls if you'll take them off. And I'm like, well, you don't know me. There's no chance in hell that is ever going to happen. And then about 30 minutes later, they came up and said, well, now the offer's up to $1,000. And I made the stupid mistake of saying, well, if I win, I'll do it. And then I won. So there was a really funny picture of Judy Graham Mason Warren and me, and she's wearing my Kansas City Chiefs overalls. And I'm like, I would have never worn my overalls if I thought I was going to lose them because I need them for the playoffs next year. They weren't very good this year, but I still need them back for the playoffs.
I guess you didn't hear my offer of $2,000 for you to keep them on. After seeing you with the overalls off, I would have upped it. So
Well,
nobody missed
I was
out.
giving you a hard time because you came up to me about an hour later and said, Ken, go put some pants on.
Yeah, yeah, I
I'm
had to
tired of
remind
looking
you.
at your boxers. And I was like, I'm wearing an apron in the front. I said, just quit looking at the back and just look at the front.
So, your wonderful, sweet daughter was there, and I went up to her and I said, Darby, is this the most embarrassing thing that your dad's ever done? And she looked at me and she said, not by a long shot.
Yeah, that's the
So,
sad thing. There is a reason why I have said many times that it appears that my life is an I Love Lucy episode many times.
no
So,
doubt.
with all that being said, and my head trying to get into this screen because now that I'm, a preeminent steak cooker,
Yeah, yeah, yeah.
we're gonna talk about a very important subject though is immigration and how that affects a bail bond because with the Trump administration we're already seeing more removals and more deportations and that's having a grave impact on bail. But so let's talk about immigration and how historically, not let's before we changed the law as it relates to 17, 16, how did bail and immigration work in Texas? Back, when back in the Old Testament when you were helping people defend bond forfeitures.
Well, that's an accurate statement because when Cain and Abel got into their little fracas, I was one of the people that approved the bond on that. But in any case, you're talking about a subject that is really in the forefront of the bail bond community right now, and that is how do we deal with number one, the people that we've already posted bonds on that we know may not be permanent residents or U.S. citizens, but have some status in this country, and what's going to happen to them as this deportation program ramps up, as well as people that we know don't have lawful status, but yet are out on bond. So, I guess to answer your first question about how did we handle it in the past, obviously bondsmen went with eyes wide open and buyer beware when they posted a bond on a person that was undocumented.
Well, but
And
they could also once, so there's different situations. So when the bond is posted, you will know whether there's an ICE hold or you won't know. And then when you
right,
post the bond, I think I've had so many calls, and probably you have too, about people saying, well, I posted this bond, they never got out of jail. No, your posting the bond was what authorized them to be released to ICE custody. And so it was your bond that authorized that release. But sometimes the going into ICE custody is right when we post the bond, but sometimes it's not for a year later. They're stopped for a speeding ticket and they say, "Hey,
right.
there's an ICE hold on you," and so sometimes the bondsmen don't know, or sometimes they know when they post the bond, and they're like you said, they're making that decision with eyes wide open. But a lot of times they don't know. There wasn't any hold when they posted the bond, or something happens after they're released from jail, and then they get taken to ICE, and before I guess the sanctuary cities bill that was passed in Texas, we were able to use a 1716 affidavit, which is an
Correct.
affidavit filed pursuant to 17.16 of the Texas Code of Criminal Procedure. Um, I mean that. I mean, looking back on that process, did you think that was a good procedure that addressed the situation, or did you think that was something that was didn't work well?
No, I thought the 1716 did exactly what it was set out to accomplish. It allowed the surety to surrender their bond while the defendant was still in custody.
Hmm.
On the strictest sense, if we're talking about immigration, the statute allowed for the fact that they were in custody of the United States government, which included ICE or INS or Homeland or whatever moniker that they used. So that was a valuable tool. The only issue or problem that we had is time was of the essence.
Hmm.
When a person was in ICE custody, at any point they could sign a voluntary departure and they would be immediately removed from the country and not have a formal deportation hearing where they might stay in custody for a while. So it really was a race to the sheriff's department to get that verification of that 1716, but at least the mechanism existed up until the Sanctuary Cities Bill amended that
Well, and
section.
I think of it as, a 1716, we're just giving notice to the sheriff where they are. And they're
Exactly.
in somebody's custody, so we no longer can perform our promise. And so the sheriff then can facilitate the issuance of a warrant, or he can have put a hold on them. And but it allows us to notify the county where they are, and if they're in immigration custody, then the judge can decide, do we want them back, or are we just going to allow them to be deported? But also, once they made that decision, if they wanted to get them deported or allow them to be deported, then the bondsman was protected. They notified them, they
Right.
verified it, and so I thought it worked very, very well.
Yeah, and I think it's important to note to our viewers that may not be all that familiar with the mechanics of bail bonds. The fact that a person is deported out of the United States and is unavailable to appear for their court setting is not a defense for a failure to appear in the state of Texas. And the ultimate outcome of that is the bondsman's responsible for the full amount of the bond and not appear. Fact that the United States come and intervene in their contractual obligation to have the defendant in court. So the only mechanism that worked as best as it could was the 1716. In my opinion, losing that was significant to our industry.
I would also point out that when they're deported, their criminal case can't go forward probably 95, 98% of the time. I mean, you can go forward once trial starts if they fail to appear, and you can try them in extension. But if they get deported, that criminal case gets put on hold. And
Absolutely.
and then it's kind of a catch 22. They've got a warrant, so they're not eligible to come back into the country, but the case can't go forward. So eventually, that case would end up being dismissed. There may be a period of time. I heard a DA tell me recently that we want that case pending for a period of time because it acts as an additional deterrent for them coming back across into the United States illegally.
I guess in one instance solves their problem, but it doesn't aid the administration of justice and bring resolution and closure to the victims of a crime. And it
Hmm.
doesn't mete out the punishment that a defendant should be dealt if, in fact, they're found guilty of the crime that they're charged with. So I don't want to say it's a free pass, but being deported back to Spain or Italy, in my opinion, wouldn't is not punishment for a person that's charged with a criminal offense of a serious nature in the state of Texas and never answers to it.
I agree with it, and but I like the notification because then they can decide whether they want them to come back or whether they're going to issue a warrant. And I think that I had a DA tell me in the last month or so of all the bad options on immigration, probably the 1716 is the least bad of all the bad options. And I think I
Right,
agree with
right.
that.
Least
And
offensive, I guess.
yes, and so that's why I was kind of surprised in 2017 when the Sanctuary Cities Bill was passed, and it contained a little provision that says we no longer could use the 1716 affidavit process if they were in ICE custody. And so, I've spent a lot of time looking at why that happened. And, the original bill did not have that provision in it.
Right,
When it passed the Senate, it did not have that provision in it. That provision was added on in committee and on the House side. And my opinion was it was added to try to get the bail industry out to oppose the sanctuary cities bill, which the bail industry was never going to do that.
well, no,
Uh,
that was a 100-page bill.
oh yeah,
I mean, it
yeah.
was just chock full of things, and I'm not even sure we were totally aware of the fact that that repealer was in there until the last moment.
Well, no, we had agreements for it to be taken back out. We had
Oh,
agreements
okay,
they were going to amend it and take it back out in the committee, but those agreements were breached. And then we had an agreement to take it out on the floor. I mean, we had a floor amendment there to take it out, and the floor debate went on so late, like at 2 in the morning, that they cut off floor debate before we got to the amendment that would have taken that back out. So
right,
it ultimately passed. It was passed with it in there. And then I think in 2021, there was a House Bill 2448, which passed both the House and the Senate to
right.
repeal A1 to restore 1716s to what they were before the Sanctuary Cities bill. But that was vetoed by the governor. And I was critical at the time because I don't feel like his office understood what he was doing. By repealing that, they said that undermined his sanctuary cities bill. Well, the A1 actually facilitates allowing someone to run and get away from answering criminal charges. So I don't think the governor's office realized that it actually did the opposite of what he was thinking would do.
Yeah, and I agree. We were very hopeful that since it passed both
Hmm.
chambers and was sitting on the governor's desk, and I think it was the very last day before it would actually become law that the governor vetoed it. So it was an extreme disappointment. But having now had to deal with the loss of that for many, many years, you and I both have told our clients that, all hope is not lost, that there's still a mechanism to attempt to put themselves in a better position. And that is, of course, the 1719.
Well,
Uh,
before we get to that, though, I have spent a lot of time talking to the governor's office in preparation for this legislative session, asking them if that were to pass again, would they assure us that they would not veto it again? And I would say, I'm not going to represent what they've said. I'm not going to say they've said something because I don't like to
sure.
speak for the governor. I don't like to speak for anybody except you. And it's always negative about whoever I'm talking to. But no, but
We can edit that out later, I think.
but I don't like to speak for them. I like for them to speak for themselves. But we've spent a lot of time dealing with them, and we are trying this legislative session to get the A1 repealed again. But like you said, there is an alternative to that, and that is if you file a 1719 affidavit, and I know we deal with those every day, but how would you describe? I mean, I describe a 1719 affidavit as a request for a warrant. How would you describe it?
Yeah, and that's exactly the way the courts treat it. You're requesting a warrant. You're not necessarily in a situation where the defendant's in custody. Sometimes they are, sometimes they aren't,
Mhm.
but most of the time they're not in custody, and you're asking the court to issue a warrant ahead of what you anticipate to be a subsequent failure to appear. So you want to kind of get a jump start on looking for a guy and getting him in custody because you have information that he's not going to show up in court. So that's how we use a 1719, as you well know, requesting a warrant. Now, there's a whole lot more to a 1719 than a 1716. There's statutory requirements that are set out in the article itself, and it takes the action of a judge to either grant, deny, or refuse in the issuance of a warrant. And then, of course, getting the warrant served would be the next step.
Well, and I think there's a
That
lot of misnomers. Just filing the affidavit. I mean, it is an affidavit, it has to meet the statutory requirements, but just filing it doesn't relieve the bondsman of anything. It just gives them the
absolutely
tools that they need to go and arrest somebody. And once they're arrested, I mean, they only then is their bond discharged. I think that's the way we teach that. But
correct.
what do you think is the biggest mistake that bondsmen make on a 1719 affidavit, a request for a warrant?
So, one of the concerns that judges have brought up to me over the many, many years that I've been doing this, besides the statement that your clients file a lot of 1719s, of course, that's the only document they ever see. So it sometimes appears there's a lot of them. But one of the things that gives the judges the angst is the reasons for the surrender.
Mhm.
Bondsmen don't need to be a prolific, novel writer when it comes down to putting why they want to get off a bond, but they need to state enough valid, credible reasons that would give the judge not only the right, but put them in a comfort zone of denying a person their liberty by issuing a warrant ex parte. These 1719s are done by the bondsman without any input from the state, usually with no input from the defense attorney, even though he's required to be given notice. So it's strictly whatever's in front of the judge on that document is what that judge has to rely on. And I've had judges tell me just putting down that they breached their contract with you is certainly not sufficient because I don't know what the conditions they breached are and whether they rise to the level that would cause me to issue a warrant and put a person in jail. So, having said that, I think they have to be more detailed, specific, and provide the court with enough probable cause, although it doesn't have to rise to that level, but enough probable cause for a judge to want to issue a warrant to put that person back into custody.
Well, and I think the statute said reasonable cause. So and there's a case that you and I both know about that says it doesn't have to be probable cause. But
Right.
some judges don't don't understand that a affidavit submitted pursuant to 1719 is almost like a police officer coming with a request for a warrant. It is
Right.
intended to be an ex parte proceeding, and also time is of the essence. So, I know in Bell County there's a judge that wants uses a 3-day waiting period before he'll sign a 1719 a request for a warrant under 1719. That's not the way that the statute was intended. There are remedies if after the warrant's issued, if it meets the requirements for the statute, that the defendant can uh, later call for if it was done incorrectly. But I think it is intended, or do you agree, it's intended to be an ex parte proceeding where time is of the essence?
Absolutely. We've always treated it that way. That the court understands the severity of the situation, and that is, the typical example is the bondsman gets a tip from maybe a cosigner, an indemnitor, that Johnny doesn't plan on being in court next Monday because he's packing his suitcase and he's heading out of state. So at that point, there's nothing the bondsman can do other than seek the remedy of a 1719 as quickly as they can, get a warrant issued, and have that warrant, either in the hands of law enforcement or their private investigator to execute it and get that person into custody.
I think judges don't realize, or maybe they do, but I don't. You don't see it very often. But I don't think judges realize that when we file a 1719, a request for a warrant, we're actually granting the judge new powers that they did not have. Because in granting a 1719 affidavit, the judge can then limit a future bond to cash only if he wants.
Absolutely.
And that's so generally judges don't have the ability to limit bonds to cash bonds in Texas unless there's a failure to appear first or a 1719 affidavit's been filed. And I think
You're
if
right.
they
That's a good point.
and I think if they use that more often, say, okay, your next bond is limited to cash only, that's a good level of accountability.
Absolutely. All those other spurious reasons that may be involved are not germane to why we want to get a warrant and put a person in jail. The primary reason is we have credible evidence or information to make the bondsman believe that the defendant's not going to appear in court.
Mhm.
And as this conversation, the criminal justice system does not work if the defendant doesn't show up for court.
Well, and there is an attorney general's opinion that says that if the affidavit, the request for the warrant, meets the statutory requirements, the judge has no discretion but must sign it.
Oh yeah, I mean that harkens back to the McConaughey case from 1977, where the appellate court said that the judge has no authority to deny a 1719. Of course, you and I preach at our schools that you don't want to give them a reason, a valid reason to deny it, and that is by failure to complete the document and supply all the elements that are necessary and do what's required under the code by notifying the defense attorney if in fact there is one of record.
Well, I would point out if there is a case or an attorney general's opinion that says if it meets the statutory requirements, the judge has no discretion to do anything but sign it, then why would you wait 3 days before signing it?
Exactly. And of course, one of the provisions of a 1719 is the fact that if the judge denies it or the judge refuses to sign it, and doesn't state a specific cause for doing that, like one of the elements is missing on your affidavit, then that's going to afford the bondsman an affirmative defense to a subsequent forfeiture. One of the misnomers about a 1719 from the judges I've talked to, and I've actually taught some classes to judges about this, is that it's a request for a warrant. It does not relieve the bondsman of liability by you granting it, but it does relieve the bondsman of liability if you deny it without cause.
I
So,
think that's a great point. I think that's a really great point. I mean, I don't think I'm not sure if judges realize by denying it, do they realize they're giving them a defense to a subsequent bond
I,
forfeiture?
I
And
I think a lot of them don't.
but the reasoning for it is what's important. The reasoning is because you have denied the bondsman the tools to do the job that they contracted to do to ensure they come to court. Something happened. They said, we're seeing issues. We're your partners in this, judge. And so we're raising an issue and bringing it to you. And all the stuff says if it meets the requirements, you have to sign it. And if they do nothing, then we have nothing. But if they mark it refuse, that gives us a defense to a subsequent bond forfeiture. I mean, they would rather grant, I think a judge would rather grant the 1719 and bring them back before them and let them straighten it out than to deny it and then have the subsequent bond forfeiture. You have nothing for the county
So
then.
let's dovetail that into our conversation about immigration bonds, Ken.
Mhm.
So we get information that our defendant that we've had out on bond is illegal or not in this country with proper documentation. And under the current administration and what is happening, we have no doubt that there's a possibility that our client, our defendant, will be picked up in a ICE raid or by immigration and subsequently deported and removed from this country. So the bondsman's faced with a dilemma. Do they use that information and file a 1719 as a preemptive measure
Mhm.
to attempt to surrender their defendants that they know there's a potential that they could be deported or removed from this country and therefore they wouldn't have a defense to their bond forfeiture. So now we're putting the court in an awkward situation, I think, because we're asking them to let us put a person in jail because we think or we believe they're not going to be available for their court setting because of the deportation and immigration rules that are in effect now. So I'm not sure because I'm not nice to give my clients about this. And I've gotten calls, and I'm sure you have too. What do I do? I got a $50,000 bond. They're not citizens. I'm afraid they're going to get deported, and I don't want to have to pay a $50,000 forfeiture. Should I go off their bond and put them in jail?
We're seeing this issue more often. I mean, the situation you talked about is we've already bonded them out, and then a year later an issue arises. I would say more often than not that we're not going to find out that they were deported in that situation until
You're right.
uh, unless a family member calls us. So, but I just don't think it's very likely that a family member is going to say, "Hey, they just been picked up by ICE a year after they were out in your bond." Maybe, but I think that's very unlikely. I mean, the biggest scenario or the scenario we see most often is where we are contacted by the family to post a bond. They say they're here legally. They say and we check and there's no hold, and then we post the bond. Because I would say right now the industry by and large as a whole does not want to post a bond for somebody who's here illegally. Uh,
Correct.
and so we post the bond, and sometime between the posting of it and the release of the defendant, an ICE hold appears. And so when that happens, under where we are right now, what does a bondsman do?
And that's my question to you. What advice are you going to give your clients? I'm telling them, look, you have to do what you feel is adequate and necessary to protect your liability. And you have to do what's adequate and necessary to make sure the defendant appears in court to answer their charges. I'm getting some feedback from DAs and county attorneys across the state about, well, if they wind up in ICE custody and get deported, I don't have the ability to prosecute them. In fact, is I don't have the ability to even bring them back to my county
Mm-hmm.
to make them appear in court because the feds, namely the INS or Homeland, won't turn the defendant over to us, won't release them from the
Well,
immigrant.
there are a couple of counties that have this policy at the sheriff's office. So if an ICE hold appears, they call the bonding company to say, "We now have an ICE hold. Do you still want your bond posted?"
Which
And
is
I think
wonderful.
I think that's a great policy. It's kind of serves as a check because the district attorney's office and the sheriff's office, they want a resolution for victims, and so they want the criminal case to be resolved. And so I applaud the counties that have that policy.
But that's far and few between.
Yes, I only know of one or two.
Yeah, you're
But I
right.
would say more, we should have more. If we're all working on the same team, we should have more counties that adopt that policy, especially during this time where we're trying to make, a souffle out of chicken scratch. I mean,
I had the opportunity to try a case that very similar to what we're talking about now, but it was many, many years ago. And I subpoenaed an officer from the immigration department to come testify before a magistrate as to why they removed a person out of the country, knowing full well that they were on a $100,000 bond for
mm,
injury to a child, which actually got elevated to murder because the child
wow.
subsequently died. And the officer testified on the stand when I asked him, did you know that there was a state case pending? And did you know the nature of the case? Yes. Did that make a difference in your decision about removing the person from the country? And his response was no. We don't care about state cases. And
Wow.
I think even the magistrate that was trying the case was taken aback by the cavalier attitude of the immigration officer at that time. Now, again, this was 20 plus years ago, but I see that the feds really don't care if there's a state case, and they're not going to defer their process of deporting or removing people from this country because they have a case pending in the state of Texas. I don't think that's in their factor of determination. They're going to
Well,
remove them.
that's one of the things that I think we still don't have an answer for under the Trump administration. Is 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 his administration taking the position that they can go into a county jail and get somebody even if a bond isn't posted. So they can go there and say, we want them, you're holding them, and we're going to deport them. I don't, up till now, it's the fact that a bond is posted that gets them released, or authorized the release that gets them into ICE custody. Have you heard anything on that?
No, I have not asked as of now,
Hmm.
but my fear is, and I think based on the same analogy that you just set out and the bondsmen have called us about, is, what do we do? How do we
True.
protect our liability?
Well, so you
And
get somebody arrested and you're called for a bond, and then you post it, and then suddenly there's an ICE hold. You're not in the county where they will call you. So let me just throw out a couple of situations. Do you file a 1716 anyway?
well, the statute says that it has no effect if, in fact, they're just in custody for the purposes of determining their lawful status in this country. If there's no other charges, no other criminal charges, then I'd say it's ineffective. Even if it's verified, I think when it came down to a hearing, I would not be able to provide that document with the authority that it's going to discharge the bondsman from liability.
I've had a couple of bondsmen tell me, well, my county will process a 1716 anyway. And so I'm going to submit that. And so and I've even argued before that the statute says you can't file it, you can't file a 1716 affidavit while they're in ICE custody to determine their immigration status. And I've argued, well, wait a minute, there's a period of time after their immigration status has been determined that they're still in ICE custody. I don't, that argument has not been litigated. I think it's a poor argument. Uh, but what is your thoughts on bondsmen saying, well, my county will go ahead and process it, and so I'm going to submit it to them?
Well, obviously, we always take the path of least resistance, and if they're willing to process the 1716 and do the verification and discharge us from liability, I'm all for it. My fear is that we're going to rely on the fact we've got a verified 1716 and it's going to give us the relief at a subsequent bond forfeiture hearing, and the state's going to object to it and point out the language of the statute, and the statute clearly says a surety may not be relieved of the undertaking if the accused is in federal custody for determination of lawful status. Now, your argument that, hey, wait a minute, the period of determining is over with, they determined that they're not lawfully within this country, so therefore the 1716 is applicable. I don't I don't have a whole lot of hope that the court's going to buy my argument, or the appellate court's going to buy my argument based on this statute. So if they're willing to do it, fine. But if it came down to contested hearing, I think we're on thin ice.
Well, and what I tell bondsmen in that situation is you're taking advantage of the county's not knowing the law. And when you take advantage of the county, it can come back to bite you. And so
Absolutely.
if they get a DA, or you upset the DA, or they get an assistant DA, I always tell the story from Ellis County before they were a bail bond board. Bondsmen were discharging liability. They would go to a hearing and see who showed up, and all the people that didn't show up, they just file a 1719 on the way back to their office, because the county was discharging the bonds just from the mere filing of the 1719, not from anything else.
Yeah.
And 1719 is a pre-forfeiture defense, not a post-forfeiture defense. You can't do that. And they had a new assistant DA come into town and research it, and she put several bondsmen out of business
Oh, yeah.
because she
Yeah.
went back 4 years over all the 1719s they filed improperly. So let's talk about, we talked about counties where they may have a policy of calling the bondsmen, checking in and say, do you still want to post the bond? We've talked about 1716s. They're not eligible for those anymore. So really, is the 1719 the only way to address this situation at this point?
Unless you've got a rabbit you can pull out of your hat, I'd say that's it.
Hmm. What else is there that we could do? I mean, I guess if once they're deported, you could show proof of being deported and then ask the prosecutor to dismiss the case. And then if they dismissed it, that would be a defense to your bond forfeiture as well.
I wish you good luck with
Hmm.
convincing a
Yeah.
prosecutor that he should dismiss the criminal case. I mean, he's in the catbird position because if he doesn't dismiss the criminal case, then he can move forward on the judgment nisi and
Mhm.
get a full judgment for the full amount of the bond. So why would he want to give up both?
That's why I tell people when you have an assistant DA that works with you and who gives you the benefit of the doubt, you've got somebody that's worth their weight in gold. Because I mean, because the rules are written in their favor. I mean, they could dismiss the criminal case the day after your bond forfeiture hearing, where they get
Correct.
a full judgment. So they've gotten that, and then they dismiss the criminal case, and they've gotten. But I just go back to bail is not intended to be a moneymaker for the county. So, I mean, that's was not the intent of bail. And if they're deported, they can't try their case. They're going to ultimately dismiss it. So why not dismiss it? But let's go back and talk about 1719s because I want to talk about where do you file it. And so let's kind of set this up for the discussion. So probably a large number of cases in the state of Texas when the person is arrested, they're arrested on a probable cause warrant. And there's a period of time then for where they're out on bail because they're arrested on the warrant. They go before a magistrate, they set bail, then they're out on bail, and then we're waiting to see if charges are filed. So during that, what we call the black hole cases, because it's they're out on bail, but no cases have been filed. Where do you go to present your 1719 affidavit? And we've had this interesting discussion at the legislature this session over this case called Ex Parte Clear, which kind of touches on this, but from kind of a different perspective, from the DA's perspective. So, but what do you tell people? Where do you go to submit your 1719 affidavit if you're in a county where they will review an affidavit before charges are filed?
It's a landmine field when it comes to these 1719s and navigating. The first thing I do is look at the actual statute itself. And the statute recites that the surety that desires to surrender their principal may file an affidavit of such intention, court or magistrate, before which the prosecution is pending. So the language is prosecution pending. So where are the charges? In a situation where you've got a bond on a defendant, that means they must have been magistrated and they must have been arraigned, same term, and bond set. And then you posted the bond and the defendant got released from custody. The case has not been filed or indicted yet. So I tell them that the judge that magistrated them and set the bail has jurisdiction over the case for purposes of 1719. And I point specifically to the statute that uses the word court or magistrate. So if the magistrate's a JP, then that particular JP has, in my opinion, the authority to consider that 1719 on an unfiled or unindicted case.
Well, in the discussion at the legislature over Ex Parte Clear, we're talking about, so let's assume that in setting bail, the the magistrate didn't do the conditions that were required by statute for the alleged charges. Or, and let's make it really complicated. You've got a warrant that's issued by one county and the magistrate in another county. And so you've got one judge that set bail, but one judge that issued the warrant. And so, which judge do you go back to? I don't think it's difficult when it's two different counties. You go to whoever who has the one that's sitting in the county that has issued the charge. I mean, I think the difficult part is when you got two different judges in the same county, that one's issued the warrant and the other's issued one issued the warrant, one issued the magistration.
And again, reading the ex parte clear case, which is anything but clear, it's kind of a roadmap, but it's not all that definitive. They talk about jurisdiction over the person, jurisdiction over the case, but from a bondsman standpoint, I think it's important that they realize it's where the prosecution is pending. I think if you've got a judge in the same county that issued the warrant and magistrated them, then that's simple. You just go back to that judge. And if you got two different magistrates in the same county, one issued the warrant, one set the bail on arraignment, then I think based on the clear case, it looks like they both have equal jurisdiction. So either one would have the ability to hear or consider your 1719.
I think that's a good point. I think, in the Clear case, when you look at it, there was three different JPs that were involved. You know, two of them were acting on behalf of a third one. But I think the point made in this article that we were looking at, Clear as Mud, from the Municipal Association was that they all have the ability to set for court for each other.
Right.
Their courts were interchangeable, and the point was made that in magistrates for a county, they all have the ability to set for each other by statute. And so I think if you're dealing with the same county and you've got one magistrate that issued the warrant, another magistrate that did the set bail, I think that the case would say you go to the one that uh, issued the bond or set bail, but I think that in that case it was the same one in essence, and so I wonder if that might have been dicta in that. But I think if I was giving advice to a bondsman, I would say first go to the one that set bail, but I think you could go to either one, and then we have the added benefit in the 1719 statute that says if the magistrate's not available, you can go to any other magistrate in the same county, which seems to be consistent with the statute that says the magistrates can all set for each other.
Yeah. To make it simple, I always tell my clients on a pre-filed case, go to the that set the bond because that's the person who authorized you to post that bond. And I've never had anybody call me back and go, well, that magistrate says that he can't consider my 1719 it because he didn't issue the initial warrant for the defendant's arrest on the probable cause affidavit that, an officer came to some judge, a week ago before they got arrested. I've never had that arise. So I've always taken the posture that if it's an unfiled case, go to the magistrate that set the bail. And I think 9 times out of 10, you're going to be in
Well, the problem
from that
that
case.
the problem you can have in these black hole cases, and because they're not opaque sometimes. And I was at a bail bond board meeting recently, and there was a discussion between two of the judges talking about uh, pre-indictment, pre-information cases, and they were talking about, well, who's keeping the records, or do you even keeping records? And so I've had a situation where I couldn't, I mean, it took me months to figure out who it was that set bail. The charges were out of one county, and when I finally tracked it down, they didn't magistrate in their county. So they took, when somebody was arrested, they would take them to a neighboring county to be magistrated. And so once we finally, and we only figured that out by talking to the DA's office, talking to the sheriff's office. And so we finally we emailed a magistrate in a neighboring county, a JP, and she said, "Yeah, I was the one that set that bond." And so we emailed her the 1719 affidavit, and she reviewed it, and she granted it, and she issued it. I mean, so I think one of the problems in these black hole cases is just trying to figure out who it was that either set bail or magistrated, because I don't think that the system is very transparent all the time.
So let me pose this one for you, Ken, and this one gives me angst. So you have a police officer that contacts a magistrate late at night to get a probable cause warrant for a crime, and he signs it, and the warrant gets put on the NCIC, TCIC, and the defendant gets stopped in Webb County, Laredo, Texas, and he's brought before a magistrate, and the magistrate sets bond, and the bondsman there posts the bond for him. Of course, that bond is eventually going to wind up in the county where the prosecution is pending,
Mhm, mhm.
and it was a Dallas case originally with a Dallas warrant. So at some point, the bondsman in Webb County wants to go off that bond by filing a 1719. Does he go to the magistrate that set the bail in Webb County for that defendant? Or does
No.
he have to get in his car and drive to Dallas and present it to a Dallas County judge or magistrate in order to get that 1719? Of course,
Well,
and there may be weeks before that actual bond gets
mhm,
transmitted from Webb County to Dallas County. So Dallas County is going to show on the computer that he posted a bond, but they're not going to have the actual bond.
mhm.
So, talk about a black hole. I mean, that's the worst nightmare for a bondsman because nobody wants to do anything because nobody thinks they have jurisdiction.
Yeah, so I mean, I think that's the biggest problem in the black hole cases, and in some counties where they're saying they don't have jurisdiction, no charges have been filed, we can't consider a 1719. I think that is, first of all, it's not correct. I understand the angst because of the black hole, it's opaque, there's not records, but there's things that you should be doing. But if we're monitoring the cases and it's taking a period of time, once your partner in the criminal justice system is telling you there's a problem with this, and the attorney general's opinion says you have no discretion, then you have to sign it if it meets the statutory requirements. We should not be having an issue anywhere in the state if a 1719 affidavit that meets the statutory requirements is being submitted to the proper officer for consideration. Now,
Correct.
they may want to ask questions. Have we re- spoken to the DA's office? And maybe he needs to speak to the DA's office. Have these charges, are they currently still pending? Have they been rejected? God forbid we issue a warrant for somebody and they get arrested, and then we find out that the DA's office has declined to file charges on that
Yeah, and
months
I think
before.
both have seen that. Not very often, but it's happened, and there's a lawsuit right
But
there.
when you have one of those happens, one time, it
Yep.
has a dampening effect on the rest of the county, and they don't want to do it for a period of time. I know we have some bills pending before the Texas legislature, and I know SB 9 and which is also House Bill 75. There is a provision in there to kind of allow a review of the bail decision that's done by a magistrate for these black hole cases. And just to kind of set out what the proposal is, it only applies to felonies. And then the bail can, they would file a motion to review the bond that's been set or bail that's been set by the magistrate. And then it would go to a district judge for review of bail to see if it needs to be modified. And it has to be done as soon as possible, but not less than the next business day. Doesn't apply to misdemeanors. Um, and if the judge increases the conditions but doesn't change the bond amount, if they're out, then he has to just give them an opportunity to come. He can't just issue a warrant. But if they're in jail, they could stay in jail while the bail's being reviewed. And if the DA wants to appeal that, I think the statute may even provide a process for appealing the bond decision. My question to you, let's apply that then to the 1719 situation. So if there's an appeal of the bond amount to the district court judge, but still charges have not been filed, do we even know now who do we present our request for a warrant to? Has jurisdiction now gone to the district court judge, or do we stay with the magistrate on our request for a warrant?
Well, since we don't have that law, we really don't know how it applies and what the mechanics are. I think my gut reaction is that if you've got an appeal from a magistrate to a district judge about the amount of bond, that would confer jurisdiction to the district judge on the bond amount and the bail matters. So I guess if that's what my situation is and not knowing exactly how this law is going to apply, I think I would defer to the district judge with my motion.
If somebody called me on that question today, I would say something very similar to that. I would say we have no case that has um, reviewed that and told us what the proper thing is to do, so we're guessing. But I would say from my appellate perspective, once you file that motion, jurisdiction is taken from the magistrate to the
Right.
district court judge, so the jurisdiction now rests with them. And I think that's exactly what you said. Um, so, I mean, I don't know if we've answered a lot of questions, but if you were getting a call today saying, "Hey, I've got $100,000 bond that I've been asked to post, and it looks like they have an ice hole," what's your advice to your client?
Run in the opposite direction. No, I would tell them that they should not post a bond on a person that they know is going to be taken from their jail to ICE custody because they're going to disappear more than likely, and they're not going to appear in court, and that's not going to offer you a defense to a failure to appear. Now, if we don't want to play games with the criminal justice system, we don't want to take money from people with the false hope that their client or their family member is going to get out of jail and come home and be there for dinner tomorrow night when we know that's not going to occur. Now, I will tell you that having practiced criminal law for 25 years ago, there were many instances where a client was in jail and they had an ICE hold, and they did have legal status or the ability to have due process in a deportation hearing. And I would coordinate my representation of the criminal case with the immigration lawyer. And if he said, go ahead and post a bond and let's get him over to immigration and we'll get this resolved and get it taken care of, and he would assure me they're not going to be deported, then I felt comfortable doing that or advising my bonding client, go ahead and post a bond because he will be available to appear in court. But I'm not sure I can give that type of assurance today based on.
Well, I mean, I agree with you completely. If you have an ICE attorney calling you saying, "Hey, I've got a client that needs a bond, we think we're getting released." I mean, probably 2 years ago, I'd say post that bond. That's safe. But
Right.
I'm not even sure I would say that today. But I would say that would be the most likely bond I would post,
Yeah.
or I would recommend a client to post. And I would say, have you done it before from this attorney? Do you have a relationship with that attorney? Then, then I may be comfortable with it. But you're still taking the risk. And I
Yeah, even
also,
immigration lawyers will tell you today they're not even sure
yeah.
what's going to happen and what remedies are available. Look, we've all heard the horror stories. We don't know all the facts. We don't know who these individual people are, but even people that are here on student visas are being taken into custody and removed from the
Mhm.
country. Now, maybe some of them have misdemeanor charges pending, maybe they don't. I know some of them were involved in some of the protests on campus, and that may have resulted in criminal actions or may not have. So I'm not, at this point, we're on such shaky ground that I think unless you're positive that the person you're dealing with is a U.S. citizen or has lawful status to be here, um, again, buyer beware.
Well, yes, I agree with you. And before we go, I want to, stress how important this information is. It's going to become more important as we go forward. And we're addressing these issues with the legislature. One of the constitutional amendments that's pending is if you're here in the country illegally and you're accused of a felony, you're not eligible for bail. That would address part of this situation. And I think the bail industry, we support that statute. I mean, we support that proposed constitutional amendment if it passes the legislature and it is
Yes.
supported by the voters. I mean, it solves our problem. We are not intending to bond people out of jail who have ICE holds. We don't. It's not our intent to post $100,000 bond, get somebody out of jail for a little bit of money, and then turn around and pay the county $100,000. That's not what we are in the business to doing.
No, no business model can survive that. And so, yes, you're absolutely correct. I think going forward, we're on firmer ground. It's trying to figure out how we deal with what we've already done in
Yeah.
light of the fact that not necessarily the laws have changed, but the application of the laws have changed.
Well, I'm hoping that we will, going forward, we'll work together, in a county as a team like we do on so many other matters when, the judges and the district attorney's office and the bail industry. And so that we'll have a fix for this so that we can notify the county. Because there are counties that they want the defendant and they want to try him and they want to put him in jail and they want to hold him for his time. And then once his time is over, they want him deported. And
Good point.
we want that. I mean, we're here to get them to court. We're not here to get them to escape justice. And that's not our intention at all.
No, both of us have testified, and both of us have proffered the position that what we do and what the bail bond industry does is an integral part of the criminal justice system. And if we're offered a seat at the table, we have a lot that we could bring to the table from our perspective that we think would help in the administration of justice. So if we're included, we can contribute.
Well, before we go today, I just want to mention that we have lost a very important person in the bail industry in Texas, and that's Charlie Pickens. He's a bondsman
Yes,
in Waco. He's a longtime client of yours and
yes,
your surety. But he was a member of the board of the Professional Bondsmen of Texas. He's on our PR committee that was instrumental in putting together the Bell Post podcast. He was Bondsman of the Year. He was um, Friend of the Legislature Award 2 years ago. He helped, he and Justin from his office designed our call to action system and our click to dial system. They also redesigned it so that we could offer it as a tool to any other state association, and it's something that is invaluable, and we'll never be able to repay the kindness that he did in helping us put that together. He he was just a good person, and I know that you know him for a lot longer than I have, and so
Yeah.
talk about Charlie for a moment.
Charlie and I went back 30 plus years. I got him an insurance license in McLennan County back in the 90s, and he for the companies that I've represented over the years. Not only was he a respected bail bondsman, but he was genuinely just a super nice guy. He will be sorely missed, but I'll tell you this: he will not be forgotten.
Great. That's a great way to end this episode. Charlie, we're thinking of you. His funeral is next Tuesday.
The 15th, Tuesday.
Okay. It's on Tuesday at 1 o'clock in Waco. And I would encourage any bondsman that knew him to attend. All right.
Absolutely.
Thank you, Randy. Thank you very
Thank you,
much for
Ken.
helping us.
I appreciate you. Have a wonderful weekend.
Thank you for listening, and come back for the next episode of The Bell Post.